After an accident, minutes matter. Your words and actions matter even more. You need help, and you need it now. This is David vs. Goliath, brought to you by Dolman Law Group Accident Injury Lawyers, a boutique firm with a reputation for going head-to-head with the insurance company giants and putting people over profits.
Welcome to another episode of the David vs. Goliath podcast. I'm attorney Matt Dolman, managing partner of the Dolman Law Group, here with my partner in crime, business-wise, Stan Gipe, and our illustrious guest today, Brett Vaughn. Brett Vaughn is a very experienced trial lawyer who's sat in leadership on a number of mass torts. And right now, you're in leadership on Valsartan, and we want to hear about the Valsartan case, your law firm, and we're going to go through a whole laundry list of topics today, but I want to start with Valsartan and introduce yourself, obviously, to our listeners out there.
Sounds great, Matt. Yeah, I'm on the Science and Expert Committee. I co-chair that on Valsartan. I'm on what's called the Plaintiffs' Executive Committee. And then my partner's Daniel Nigh. He is the co-lead counsel of that litigation. Marlene Goldenberg's also on the Executive Committee with me. And then my other partner, Ashley Raso, is on the Steering Committee for that litigation. It's actually one of the ways that we all really started working a lot together back in probably about 2018, and then about a year and a half ago we formed our own law firm, which is the Nigh, Goldenberg, Raso, and Vaughn.
And that firm has grown very quickly too.
We have. We've grown quite a bit. We've added some more attorneys. We actually just signed another attorney that was a law clerk for us yesterday.
And Marlene, if I'm correct, Marlene is on leadership in the Uber rideshare sexual abuse litigation as well.
Absolutely, yeah. She has a lot of sexual abuse litigation. The Uber one is one of the main ones she's doing, along with our associate, Sam Hoff. She does just incredible briefing and does a lot of the briefing in that litigation.
Interesting. So let's start with Valsartan. Where are we today? What is Valsartan? What does it cause? Catch us up to speed.
So Valsartan back, in 2018 is when this recall initially happened. It was recalled because it was contaminated with a carcinogen primarily called NDMA, or N-nitrosyl dimethylamine, which is a nitrosamine and would be one of the most just carcinogenic compounds to mammals. It's actually what they give rats to induce cancer in the lab. At the time this was recalled, it was one of the most popular medications that people were on, probably like almost a percentage point of the population. And it's for blood pressure. It's called a ARB, it's an angiotensin reuptake inhibitor. And so a lot of people were taking this for their blood pressure, and it was just the generic version that was contaminated. And so we're doing lawsuits strictly against the generic manufacturers, which is a lot different than most mass torts. Typically, you're only suing the name brand company. You're only able to legally because of some legal precedent on failure to warn. But because in this litigation it's a contamination, we're able to actually sue the generic manufacturers for once.
Got you. So as we sit here now, where are we in that litigation? So, to catch you up to speed with what we often talk about in our podcast, Stan and I often discuss, most of the projects that we're involved in are pre-Daubert, meaning Daubert is a scientific standard whereby federal courts, who serve as the gatekeeper for scientific evidence, they determine after hearings, which are called Daubert hearings, whether the experts use sound methodology, whether they can repeat these studies and produce the same exact conclusions, whether that's accepted science, has it's been peer-reviewed in real legitimate medical publications. Like, where are we right now in Valsartan? How close are we to Daubert, and then where does this case go?
Great question. So we're about 6 years into this litigation, and we passed Daubert actually in this litigation a long time ago. So we've had a few rounds of Daubert, which is a little unusual for some litigations, but it's because we have personal injury cases in this litigation. There is an economic class action, and there's a medical monitoring class action, and so we've had to have different Daubert hearings with experts. For the general causation phase, so proving that this caused cancer, we passed the Daubert probably over 2 years ago, and just in spades. Basically every single cancer that we were going after, we were able to get through Daubert on. And so we have great support from our experts here. One of our experts is a Harvard scientist that actually studies cancer by giving this chemical to rats. So very, very clean science here. It's been known for a very long time that this is a potent carcinogen. And then, we were able to find the documents that the levels that these were, the carcinogens were, the drugs were very, very high. And so that really helped us passing Daubert. what the defense is doing now, because the facts are very, very bad against them, with us passing Daubert like we have, and now the internals that we have showing that it looks like they knew the entire time what they were doing and shipping this to the United States. They're now trying to kind of re-challenge Daubert. I don't know if the 702 kind of rules that have come out, which really don't change Daubert, it's just saying that, Daubert is what it was, and the standard for expert admissibility is this. It didn't change the standard, but defense, it's their new tactic to try and always say now, well, there's a new standard, it needs to be reevaluated. And so with the Valsartan litigation, we were supposed to go to trial a couple months ago for the very first trial, and the judge ended up retiring. And we got a new judge just recently. And, they didn't bring up, the Daubert prior rulings before we went to trial, but now they're trying to bring them back up again and say, well, there's new rules, 702's changed, we have a new judge, we need to reevaluate all the experts again. And so they're backed in a corner at this point in the litigation. It's kind of like they're kicking and screaming and trying to throw a Hail Mary.
Gotcha. Let me ask a question. Well, yeah, because the first thing that pops into my mind is usually you're shooting at one manufacturer. We got name brand, stuff like that. This being a little off in that you're going after all of the generic manufacturers or several of them. Was the same contamination going on at multiple facilities? Was one facility manufacturer? Like, how'd you end up with all the generics, experiencing contamination?
It's a great question. One of the things that I was really curious about when the litigation started and we started seeing the mass recalls was, we started seeing one recall, and another recall, and then another company. Then another company's got bigger, and the other company's got bigger. And it's like, why is this so pervasive? Why is this contamination so widespread? And what really happened was, it was kind of like almost globalization, like the negative impact of it, and just the supply and demand of costs of how much it costs to make this medication. So the name brand medication, the chemical process that they were using, it cost a decent amount of money to make the medication that way, but there was no risk of this causing these nitrosamines. And this company, ZHP out of China, figured out was if they used a different chemical process and used these really cheap chemicals to make the drug, they could make it and they could sell that drug cheaper than anyone else could make it. And so they're selling it cheaper than anyone else can make it. But it makes a lot of carcinogens when they do that. And so they're flooding the market with this cheap Valsartan, and no one else can compete. And so everyone's looking to do the cheapest process they can now to make Valsartan, and the Chinese Valsartan takes over the market because it's so incredibly cheap. Every single company, distributor, is buying theirs. And so that's what their market share just explodes. And that's what they talked about wanting to do, is they wanted to literally dominate the world market, and they were very successful in doing so. The contamination levels are different from the different manufacturers. I will say that. The stuff coming out of China is ungodly high levels of carcinogens. The stuff coming out of India has carcinogens. They are high levels, definitely dangerous. It's not as bad as the stuff coming out of China. They were using slightly different chemical processes in some different instances of why it was happening. But a lot of it just came down to what's the cheapest way we can make this drug? Can we recycle the solvents? Can we recycle, whatever chemicals we're using? Do we have to clean these machines? And then just, can we make it cheaper? That's really what I think drove all of this, was them trying to make as much money.
So kind of juxtapose this versus Zantac. Mm-hmm. Zantac, wasn't that regarding NDMA as well?
Yes.
That was found, that nitrosamine. So I know that failed in the Southern District, in the United States District Court of the Southern District of Florida. Judge Rosenberg flushed that case out on Daubert. What's different about this versus that, and kind of juxtapose those two cases?
Yeah, a lot of people say you just have a different judge or something. I think it's a lot more to it than that. But at the same time, they are passing those standards in a lot of different state courts on Zantac. Mm-hmm. But the real big difference here that I see is how that carcinogen is being formed. So in Valsartan and the generic drugs, the carcinogen is being entered to it, like I was talking about, because of a chemical process. And we can quantify the amount of NDMA in a Valsartan pill. The companies did it, the FDA did it. We can see how much is in there. And for Daubert, that's very important, because then I can go to the literature on NDMA as opposed to the literature on Valsartan. And I can look at that NDMA literature and say, if you have this level of NDMA, it can cause cancer. And so then I can just look at these pills and say these pills have that level of MDMA. So that literature helps support it a lot. There is also literature on Valsartan that was contaminated increasing the rates of cancer. So we do have that. With Zantac, what becomes hard on it is that it's not a contamination case. The actual molecule, ranitidine of Zantac, breaks down or decomposes basically into NDMA. And so if you leave your pills out somewhere that's very hot for a long time, that could end up turning the pill into having a lot of NDMA or carcinogens in it. It's like if you left it in your car in the heat. Also in your stomach, or later as it's being metabolized in your body, it could metabolize into NDMA. What's difficult there on proving that in court is how much NDMA is a specific person ingesting each time, because it's highly variable based on if it was in the heat and all of that type of stuff. And so it gets hard to prove that you had enough exposure to cause cancer. That was probably the biggest difference between the two litigations.
Got you. So now as we sit here, sorry, Stan.
No, I'm sitting here going, as I do this, I'm your typical consumer, right? Ignorant and everything else. I read, hey, store in a cool, dry place, and completely ignore this warning on a lot of stuff because it really doesn't mean anything to me. So if I was carrying an indigestion pill, Zantac, anything like that, I'm carrying it in my car and leaving it in the center console because I'm going to have it when I'm out at dinner.
That's what I've always said too, and the companies sometimes will try and use this as a defense and be like, well, we told them not to have it in the heat, and it's like, well, if it's going to turn into a carcinogen and kill me, you need to have the warning say, like, don't have it in the heat, or this is going to turn into a carcinogen and kill you. Otherwise, I think that maybe the med's just not going to work.
That's exactly my thought about keeping it out of the heat. Had nothing to do with some kind of transformation into a carcinogen.
No.
It's just, hey, this drug may be slightly less effective. I never crossed my mind that it might kill me if I leave it out there.
Sure.
Mm-hmm. Yeah. And then the other big difference between the two, I would say, even, like I said, because Zantac is passing expert standards in state courts, you will see a difference on what cancers are associated with Zantac versus Valsartan. Valsartan is much more associated with GI cancers, and Zantac can hit a little bit later in the body, the bladder and stuff, a little bit easier because, it is turning into the carcinogen in the body a lot of times, and so it can get farther through the metabolic pathway of the body and hit some other organs, as opposed to Valsartan. It's going to hit organs that are a little bit earlier, typically.
So what is a signature injury?
For Valsartan?
Yeah.
Bowel injuries, especially bowel cancers, GI cancers, your liver cancer, definitely blood cancers, non-Hodgkin's lymphomas, stuff like that. Those have a really low time latency, so time from exposure to getting cancer, so you'll see spikes of that. And then also you can get lung cancers and stuff from it, thyroid, and areas in that area.
Real quick, who is it that's actually a claimant for this? Is it anyone who's taken it because it takes a while for cancer to develop, or do you have to already have the cancer to really enter into this litigation?
A few aspects of this litigation. There's a class action going on that's for medical monitoring, so that would be anyone that took this contaminated medication and at a high enough level that they are at a higher risk of cancer for the rest of their life. And so we're trying to get them, medical care so they can get screened, so if they do develop cancer, they can catch it early and have the highest survival rate possible. We then have an economic class action for the consumer. So if you have a copay with your insurance and you're having to pay X amount of money every month for your drugs, our claim is that there's no way you would have paid that money if you knew that there were carcinogens in it. So we're trying to get people their money back for paying for cheap, worthless drugs. And then the third one would be people that actually have got cancer, and that's different as far as the way that works legally. So the other ones are class actions. You're going to automatically be opted into that. With the personal injury claims, if you develop cancer, you're going to need to contact an attorney and actually file a specific lawsuit for your claim on that cancer. And that would be if you've already developed cancer. So if someone develops cancer in the future, then they would have to file a lawsuit to have a claim on that, as opposed to
Makes sense.
For the economic part, for just paying for the meds. That makes
how
sense.
big are these generic manufacturers? Are they, and how solvent are they?
They're very large. Obviously the one that did the worst as far as the contamination, ZHP, which is out of China. They're in China, so there's some concerns there, but they do have U.S. subsidiaries such as Solco, and they do sell very large amounts of medication still in the United States. Initially, the FDA rightfully put them on import alert, which is banning them from importing any medications in the United States because they had no quality control at all. The FDA has lifted that import ban I think a couple years ago, and so they are able to send medications back into the United States. They do have a big stream of revenue from the U.S. They're going to want to still be able to do business in the U.S. What I initially kind of thought was, who is going to do business with this company after they just essentially poisoned tens of thousands of Americans and got put on import ban for 2 years? Like, go ahead and lift import ban. Who's going to buy these medications? The same companies that were buying them before are buying them again because it's the cheapest meds that they can buy.
Isn't that sad?
It's really sad. It's like none of these companies learned their lesson. Like the U.S. distributors that are selling these medications, because when you go buy your med, it doesn't say ZHP, this came out of China. It says Teva. It says Tort. It says some company that you're familiar with. They just bought the drug out of China. Now they're reselling it. And this litigation has made no difference on where they're sourcing their medications. It's about what's cheapest and what's going to make the most money.
What's the next step? When are we at Bellwethers? When does this come in for a successful landing, or how close are we to that?
Another good question. It's a harder one to answer because we've had this change in judge. Our next case management conference, which will be our first case management conference with this new judge, is set for later next month. We're hopeful that we'll have our first trial later this year, sometime in the fall. Might be too ambitious, I don't know yet. But as of right now, it's still set for that first trial to be on the consumer class action. So for the economics for paying for the medication, it makes some things a lot simpler, not having to go through general causation stuff at trial, and then a lot of that can apply to future trials. That's currently what's set first. There's not a schedule yet for the personal injury Bellwether trials. We're trying to push for that as much as we can. There have been a few settlements here with Valsartan. There was one it's probably a year ago, a very small one. And then there's one that's being worked on currently. There's been some orders out there that with Hetero, which is one of the Valsartan defendants. It's a very small defendant. When I'm kind of crunching the numbers right now, it looks like maybe around 3% of Valsartan cases on file is Hetero. So one of the smaller defendants, but they do make stuff like Losartan and Irbesartan as well, which they are larger defendants on. So we are seeing some movement with the defendants, but when you have a defendant out of China, they like to push the legal system, I think, as much as they can.
Makes sense. So let's segue for a little bit to another mass tort project that I know we've spoken about personally, Brett and I, last week. And I know you're involved, but peripherally. But if you're involved, you're involved. I mean, you have I would say, a titan of a mass tort firm. So you guys have a nationwide reach. You're in a lot of projects, whether you're on leadership or not. And this one is Suboxone.
Absolutely.
It's one that sits on leadership. We got involved early in Suboxone. Tough clientele, which is nothing. That's not saying anything wrong about the clients, and never would I paint anyone with a brush. But it's just in terms of retention of clients, it's been tough. But I believe that case is off to a good start. We got a great order that came out on Monday from Judge Calabrese denying bifurcation, where defendant Indivior was trying to phase discovery, have general causation go first, where we have to prove that using X causes Y. So in this case, using sublingual Suboxone causes general tooth loss, or at least in this case, tooth decay, but really we're only taking on a case with tooth loss. And now we're getting to, we're going to combine both general causation and specific causation at once. And specific causation for those out there is Johnny, used Suboxone and that caused his individual tooth decay or tooth loss. Where do you think this case is going, and what's your 10,000-foot view of the case?
One of the first things I look at when I'm evaluating a litigation is the science on it. Like, is it going to get past Daubert? Is it going to be able to hit specific causation? This one looks really good to me. That simple what is going on. It's a very acidic product. You're putting it in your mouth. You're putting it right next to your teeth. And they weren't telling people to rinse their mouth out. And at some points they were telling people to brush their teeth, which would brush your enamel off. There's lots of studies out there that show, this type of mechanism of action being very harmful to teeth. But what's big here, too, is we have the FDA at least somewhat on our side. They've come out, the FDA has reviewed reports, they've reviewed literature. The FDA themselves found the association, which is a very big deal. They made them do a label change. It's not as strong as I think the FDA should have mandated. I'm sure there's a lot of back and forth with the company and the FDA, and I assume that's going to be found in discovery soon. But those are very good signals to me that the FDA is on board with it and the science is clean. We should be able to get past general and specific causation without much trouble. And as far as the clientele, I mean, I agree, because these clientele are put in a really difficult position. And it's a similar position I was talking to my staff about of how people in Valsartan were put into, where they got a recall notice that they were taking a drug with a carcinogen in it, and the FDA was telling them, like, but hey, don't quit taking your drug right away because it could kill you, because, you know, you have hypertension and you might stroke out if you quit taking this. Like, you need to take the time to actually transition to a new medication. So those patients were really freaked out on if they should really be taking that med, because they were increasing their risk of cancer, but, you know, they weren't going to die that day. And it's similar here with Suboxone, where you have someone that's either in like horrible chronic pain, or you have opioid addiction, but now you realize that this medication is rotting your teeth out, and you would prefer it not to rot your teeth out anymore. And so you're just like, well, do I quit taking this today and potentially relapse, or keep rotting my teeth out while I try and get into my doctor and see if I can find an alternative medication now? Like, that's not an easy position to be in.
How tough, I anticipate at some point Indivior is going to phrase the question, though, what's worse? Tooth decay and tooth loss, or, you know, addiction to opioids? And I get the answer to that question. I know we're going to somewhat argue. I don't want to hear Brett's thoughts on that, though. I know Stan's piping. He's ready to go with another question. Where do you combat that question? Where do you combat that legal analysis or that thought?
That's a straw man argument, because there's other alternatives out there. This isn't the only thing that can treat opioid addiction. You could have, and even Suboxone itself can be used, just not the way it's being used here. There's lots of other administration methods, even for the same drug, that will not cause your teeth to rot out. And then you have alternatives that aren't Suboxone, such as a methadone or something like that, that could be used too. So there's plenty of safer, available alternative drugs. This one wasn't needed.
Yeah, I agree with you. I mean, really, the problem is, you know, these people, they got their teeth rotting, right? They're not attributing that to Suboxone. They got no reason to adjust or use, no reason to say, hey, let me rinse my mouth, no reason for their dentist to say, hey, you need to switch up what's going on with this Suboxone. So there's no reason to associate it. And we have kind of two buckets of clients, though, because you got your people who had an injury, you know, let's say post-surgical, scripted pills, and they get addicted, right? And then you've got sort of a second bucket of clients who have experimented with street drugs, you know, through whatever method and got addicted. Obviously, you know, that second group of clients, because of the nature of street drug use, they can be more transient, harder to get hold of, that kind of thing. And because of that, I feel like Indivior and some of the other defendants feel like, as a whole, we're going to have a poor presenting group of clients because of the stigma that attaches to, let's say, drug addiction.
Maybe. I mean, at the same time, as far as injuries go, it's a very visible injury. I think it's going to be a very visible injury to a jury. I know when I've seen the pictures, it's been shocking to me just how bad these injuries are to someone's teeth. And it's not, you know, I was kind of basically phrasing this as a defective product that shouldn't be on the market, but there's a lot more to it. There's also the failure to warn, where they weren't telling anyone about this. And on top of that, like the failure to instruct them how to use it properly, where, you know, if your teeth are starting not to look as good, what are you going to do? You're going to brush your teeth more. In this instance, that's going to make it worse. It's going to take the enamel off your teeth because of how acidic this stuff is. There's lots of layers to this case where this company just was not instructing people to do anything to prevent these injuries.
You know, I've talked to people who have used this drug that we represent and other issues. And, you know, I remember one of the most striking things one of the guys said to me was he talked about how he would take it. And he said, well, you know, during the day it would take maybe 10 minutes at least to dissolve in my mouth. But then he goes, the one I would take before I laid down to sleep, he said that would sometimes, the residual would be in my mouth 2 hours later when I woke up, or 2.5 hours later in the same spot. And I'm going, well, yeah, I can see.
Oh, that's interesting.
Yeah, I was like, but you think about it, when you're sleeping, it sits so you don't have the same saliva production, all that stuff. I'm going, well, yeah, that makes sense, but it would, like, hey, it's not cross his mind. Just like I take this when I lay down, that's the one I take before I lay down. And that's probably doing the most damage to his teeth.
I would assume so.
Horrific. So where do you see this case going, Brett? If you had the crystal ball out, what's the next step, if you will? Because we know we're going to go through phase discovery. We're eventually going to get to Daubert. I know we all both think it's going to pass Daubert, but where's the pressure point on Indivior? Are they going to try to sever these claims? What's the next step?
It's a really good question, and I wish I understood how defense evaluates these cases even better. I know what I would do if I was in their shoes. I've kind of talked to you about this a little bit, Matt, is I would look at the CPAP litigation, what they did. I think that was very smart of those defendants, where they settled the litigation out before Daubert, and then they get a lone pine order, and that makes it really hard for cases to progress after the entire litigation is settled, because you're not just doing specific causation reports, you're having to do an entire batch of general causation reports.
What's a lone pine order?
Yeah, so lone pine order is basically so right now we have a direct filing, easy order in like Suboxone stuff, where we can just file your lawsuit in there and we're good to go. Once a lone pine order comes out, typically, they can be different the way they're phrased, but typically you can't file the lawsuit until you have an expert that's written an expert report supporting your claim, and then you can file it. So it takes a lot of time, it takes a lot of money and stuff like that to do. But if it's just a specific causation report, I only have to do it with one expert. If I have to do it general causation reports too, now we're looking at quite a few experts and much, much harder expert reports. And so the barrier to entry to file a lawsuit just skyrockets if you settle a case out like they did in CPAP. So if I was the defendants and I was looking at something like Suboxone, where I don't see any chance that plaintiffs don't get passed on Daubert, I would go ahead and settle it out before Daubert, because then you can get a real tail on the litigation. And by a tail on the litigation, I mean like you kind of wrap it up and you wrap up your liability. If you get past Daubert, then even if you settle out the whole litigation, as long as you have a specific causation expert, people can keep filing lawsuits against you. And a lot of people took this medication. It's, percentage points probably of the population or close to it. There's a lot of cases out there. So if they want to tail on litigation, I think the way that would make the most sense would be to wrap it up right before Daubert, or right before expert reports are exchanged. I don't know if defendants are savvy enough or want to, admit to anything like that, but I think that would make the most sense.
So one of my takeaways from my initial conversation with you, Brett, was you had and we could talk about this offline if you don't want to talk about it on the podcast, but you had a very unique perspective on the statute of limitations in Suboxone, and how
Absolutely.
A lot of us probably neophyte, and I call myself a neophyte in mass torts. We're experienced trial lawyers, especially Stan. I mean, Stan's a warhorse in litigation, but that's on single event cases. In terms of mass torts, this is the first one we served on leadership in. And not that we're rookies, but compared to you, we relatively are. What is your perspective on the statute of limitations, and why, certain states are 2-year states, 3-year states, 4-year and 5-year? You're looking at it completely different.
Yeah, and it's for a few different reasons. And some of them we can go into more detail offline on, as far as filing strategies and based on where the defendant's located, and some prior case law that can attach, the discovery rule from other jurisdictions on there. So that's one part of it. The bigger part really for me on this litigation is anytime you're doing an SOL analysis, it's a very case-specific analysis, the fact-intensive, and a lot of people, that label update is not going to put people on notice as to what this drug can do. There's lots of different label updates you can do. The highest one is it's now called a boxed warning. It used to be called a black box warning, and that's at the very top of the label. They'll put actually a black box around it, and it'll say like, yo, you really need to know that this can rot your teeth out before you take it. That would put most people on notice, without a doubt. Below that would then be on the front page of it, you're going to have your warning section. You would put it there. So someone, when they open it up, would say, okay, what can this do? And you'd see it. They didn't add it there. They have a lot of warnings there. There's nothing about tooth decay. They went on about page 8, they put, this can cause some dental problems, and just put a little bitty paragraph in there. That alone, I don't think is enough to put someone on notice. Even more, think if you were taking this drug for 6 years, you're filling up the pharmacy every month, you go and happen to fill at the pharmacy June of 2018, June of 22, you go and fill this drug. There's nothing in there that says, hey, you need to read the IFU, it's been updated. There's no reason you're going to read this entire IFU again now, because page 8 has that on there. There was no Dear Doctor letter to let your prescriber know, hey, this could have been a side effect, you need to look at it. There was no Dear Patient letter to say, hey, you were taking this medication, it could have caused this, you should look into it. And so the vast majority of people, I don't think, would have ever known that this could have caused their teeth to rot out until they started seeing attorney advertisements. And that's what I'm hearing from every client I'm talking to. They're saying, oh my gosh, thank you so much. I had no idea this could happen until I saw, your website or someone's ad, and I finally realized that this could happen. The other type of people you have is someone that was taking the medication, back in 2018, 2019, 2017, and they're no longer taking the medication. They weren't taking the medication when the label changed. How on earth would they have been put on notice that this could have caused their teeth to rot out?
That's an interesting take. I like it.
Yeah.
I hadn't really thought of it that way because it's a newer should have known standard. I think everyone or the vast majority of people are taking the sort of the simple thought of, hey, once that warning's put on, that's the trigger date for the statute of limitations. But I guess it's fair. I mean,
I knew you wanted to hear this, Stan, because I came off of a red eye from San Francisco from the heavy metal baby food hearing, and I was talking to Brett, so I didn't have a fresh mind when I heard it. I'm like, wait, what?
Look,
Uh-oh. And I kind of wanted to cry because we've turned down so many clients based on that.
And I appreciate you turning them down because a lot of them came to me. They're like, hey, you don't take Arizona, right? I'm like, yeah, we take Arizona. Don't worry about it. But when I was hearing the same thing from people as you guys were, and so I was going, oh my gosh, this must be some fantastic black box warning they got on this drug. And I go to the label, and I'm like, I can't find the right IFU. And I kept thinking I was pulling the wrong IFU. And then I read the full front page. I'm like, I'm reading the wrong IFU. And I just kept reading. And then finally I was like, oh my gosh, this is the IFU they're talking about on page 8 or 10. It says dental damage. This is not enough to put someone on notice.
Well, 100%. I can tell you as I sit here, I'm talking, you rip those little booklets open, you try to read. I mean, you have a hard enough time reading how many pills to take and under what cadence. And it's all tiny. It's all written. I can't tell you I've ever gone to page 8 to look for safety concerns with the drug.
No one does, of course.
No. It's like page 5 that tells you not to brush your teeth. That should be the first thing it says on there. Don't brush your teeth after you take this medication for over an hour. Like, that's the most unintuitive thing I've ever heard in my entire life. You don't want your teeth to rot out? Don't brush your teeth. Like, that needs to be a very prominent warning because that's the opposite of what you would think.
Yeah, common sense tells you right away, I want to brush my teeth, clean my mouth out, get this out, get any remnants out of there.
I'll tell you, what I'm most interested in for this litigation is the discovery specific to that. There was a 6-month period from the time the FDA found the association, said they were going to make them update the label, until the label was updated, and it was one of the weakest label updates I've ever seen. I would love to see the draft IFUs, the comments on there, and what the marketing and leadership at Endeavor was saying about the label change, because they did everything they could to make that the weakest label change possible. There's going to be good stuff there.
Agreed. So while we have Brett Vaughn on, in our previous podcast, Stan posed a question that he's now posed to about, good 50 people, and he continually confounds me at just how wrong he is. But Stan, why don't you go through your insurance? Because Brett's not a single event guy like us. So, I mean, they do some single event stuff, but they're not like us, and we are the proverbial car accident lawyers. Take him through your little insurance analysis and the crazy question that we went through in the on our last podcast. I think Brett's going to. He's going to find this to be very interesting, and I'm intrigued to think about what I think I know what he's going to say, but and actually it came out of Missouri, this case, so this might be of interest to Brett. He may have already seen it in legal journals.
You're talking about our HPV case, right? The one, okay.
Yeah, go through it.
So, lady sues. Okay, so here's what happens, right? And we're talking about foreseeable use of an automobile, right? Foreseeable use. And you know where this is going. Couple meets. They go outside the bar, go into the car, have sex, right? A disease gets transmitted that ultimately causes cancer and significant problems for the lady. So his HPV ultimately caused her cancer. Assume the causation is there. Like, I know that's a tenuous thing, but this has gone through arbitration. Award was there. There was a denial of coverage. So the causation argument stuck. They can't challenge that. Where they're at is challenging coverage, right? And this is boiling down to, is this a foreseeable use of an automobile vehicle with ambiguity construed in favor of the insured? And when I sit out there, if you ask people for things they've done in automobiles other than drive, like if we were on Family Feud, right, and there's like the top 8 answers, Okay, one of those is going to be have sex, right? Everyone, when they lived at their parents, this is what they did. So I think it's completely foreseeable that someone would use the vehicle to have sex, and at that point, I think it's foreseeable that a disease could be transmitted.
And before Brett answers this question, and by the way, Stan is one of the more prominent trial attorneys in the Tampa Bay area, had the biggest verdict in Pinellas County back in 2023 at $6.4 million. But I completely think he's a complete fucking idiot. Here's my opinion on this. Okay, and I love Stan.
You're saying that your car insurance should cover.
Well, yeah, that's what's up right now. It's up on appeal in the.
With a federal judge, by the way, that did say that he does inures to the fact there is no coverage, that is not the intended purpose of an automobile. The intended purpose is to operate the automobile, like put it in drive, start the ignition, and drive the car. Events coming out of that or transpiring as a result of that car being in motion, one cannot see that any more than one could see a homeless person taking up residence in your car at night when it's cold and catching a disease as a result of being, subject to the inclement weather outside. But Stan sees sexual activity in the backseat of an idle car as foreseeable and should fall under insurance coverage. So where do you stand on this issue, Brett? I'm curious.
I'm quite the plaintiff's attorney, and I think that you are really making a stretch there. I think it might be against public policy for my insurance rates to go up that high here in Kansas and Missouri. I think you got an uphill battle on that one. That's going to expand what they have to cover insurance-wise massively and change a lot of algorithms that they use. I don't see that one going.
I think they just need to change the language of the policy, right? I think it's a poorly written policy. But listen to the case I've had and settled, right?
What else are you going to exclude? All these other unforeseeable events? You're going to exclude sexual activity
any
and
transmission of disease. I'm sure they thought of that after COVID-19, right? People probably trying to sue Uber because they So I'm sure disease.
There's cup holders, but make sure not to drink while you're driving because you might choke.
Hey, well, listen. Okay, so what distinguishes this case, right, from a case I had where my client was a lady of the night, right? She's a prostitute and some guy picks her up. They go to sit in a parked vehicle, right? She begins doing what she's going to do, and without getting vulgar, she's in a position where her head is between this guy and the steering wheel. Okay? At a particular moment during this act, the guy got excited, hits the gas, and runs into the wall in front of them, thereby crushing her head between him and the steering wheel.
Driving incident.
Right? But
the car's moving, Stan. The car's moving.
It's a driving incident.
She's injured is because her head is in his lap performing a sex act. While the car is
moving, Stan.
So if they transmit a disease while they're driving, is it covered?
No, the disease transmission part's not covered. Him wrecking it because he's doing that while he's driving, that's covered.
Agreed.
Okay, so I don't think that's any more foreseeable than the sex in the vehicle. I am obviously in the minority here because nobody we've spoken to with any sort of legal knowledge whatsoever has agreed with me.
I thought you were going to say I was the only one that disagreed with you. I was going to
No, you're actually, you proved to have a brain. But Stan, with disclaimer, is a board-certified civil trial lawyer, did pass the bar in his first try. We just wonder how that happened.
I like the creative arguments. I mean, that's the good part of it. You just gotta cut them when you've lost.
Well, hey, this is still up on appeal, right? The cover, there was basically what...
Sometimes that's a win, as long as you can keep the case alive.
What happened was there was an arbitration award for $5.2 million after a denial of coverage. The Geico tried to jump in, say, hey, we shouldn't get this. Court said, no, it's too late. So, boom, it stuck. And then Geico's like, all right, well, now they file a declaratory judgment action. Okay, first in federal court, first layer of court has said no dice, no coverage. They just had the appellate arguments where the court does acknowledge that this is a foreseeable use of an automobile. It's not so wild and out there that you couldn't fathom this as a use of an automobile. I haven't seen the order, but I have a feeling, based on everyone else I've spoken to other than myself, that it's probably not going to go in favor of coverage.
You should talk to my partner, Daniel Nigh, too. He was attorney for Geico way back in the day, so I'm sure he has an opinion on it too. It's probably not favorable to you either.
But we just want to leave you with the premise that, we're going to refer you all of our Valsartan cases in consideration for if you get any cases where any individuals, obviously, they were diagnosed with HPV or any venereal disease after using their automobile. Stan chairs that department at our firm. Those are the big cases he's looking at on a daily basis. We love those cases.
We will look more into it and see if any of our current clientele fall in there.
I do believe transmission of a sexual disease is covered under general liability as long as there's no exclusion.
You're out of your mind, Stan. So going forward, Brett, tell our audience how do individuals get a hold of, is it NGRV? Is that the how you can say it?
Yeah,
is that the acronym?
NGRV or Nigh Goldenberg. So the website is nighgoldenberg.com, or you can type in NGRV into Google and it should take you basically to us. Get a hold of us through intake. Our emails are all on our profiles, so you can reach out straight to any of us if you need to.
So you guys are handling Uber rideshare litigation. So victims of sexual abuse in an Uber rideshare. You're handling Valsartan. What are some of the other products you're currently doing?
So my main project has always been hernia mesh, and then Valsartan is the other project that I work on. And the hernia mesh project is very large. There's numerous defendants on that one as well. But as most litigations, those are different litigations. And so there's like a barred hernia mesh litigation, a Covidian hernia mesh litigation. There was one against Atrium, against Ethicon and Johnson & Johnson, and then against Gore as well. And so it's all hernia mesh, but lots of different products and defendants. And so it's a whole bunch of litigations and takes up.
Are most of those close to being over, or they're all in different stages?
I'd say the majority of it's close to being over. Okay. Or has either resolved or is in the process of resolving. But it's going to go on still for several years, even if, with settlements as they happen, those take, years a lot of times to administer. And then there's still random defendants that are litigating or will be litigating probably for a few years. So it's still a long project for me.
Understood. Brett, it's been a pleasure having you on today. I had to stump you with Stan's crazy question that he has now fielded to our entire staff. Now we've gone through a podcast. Not one person, even by accident, has agreed with Stan.
Well, hang on.
But Stan's still fighting the good fight and holding that, burn that candle out
I think everyone agrees that it's a foreseeable use of an automobile. I don't think anyone's...
I think everyone... I mean, yeah, I get what you're saying there, but...
Come on. What do you think goes through that 50-year-old guy who's out looking at the Ferrari at the dealership? That's half the reason he's buying it.
No, he's not. He's hoping he gets laid because he has that car and impresses women. He's not hoping that he gets laid in the back seat.
Yeah, not in the Ferrari. The thing is way
using
too
a
small.
Ferrari?
Not a Ferrari. No, he's trying to pick him up and take him somewhere in a Ferrari.
So Ritz-Carlton, he's not trying to get laid in the back of his car in the back seat of a Ferrari. Come on, Stan, your argument gets worse the more you argue this thing.
Imagine if it's a Ferrari, it'd be the front seat.
Yeah, he's probably driving at the same time then, and then it'd fall under policy.
Yeah, the car would be operable, as Brett and I have tried to explain to you.
Well, hang on, but without a wreck, there's still no coverage, right? Even if he's driving around and transmits a sexual disease, yeah.
Yes, that's not foreseeable.
Yeah, so what if someone's sitting next to me and we're not wearing masks and I give him COVID? Is that foreseeable now?
Well, hang on. It's foreseeable, but I don't know that it's covered.
Okay, it's foreseeable. It's not covered.
Well, I don't know.
Stan's one with diamonds.
No,
all right.
Stan's like, I got a new idea. What about COVID transmission in cars?
I am sure that
this firm's going to be out of business in about a year.
I am sure that some insurance company has addressed this with policy language, right? Because there was COVID litigation on all these GL policies about could they shut down? Was this actually a physical presence in the shop that and people.
So now you're drawing an analogy between business interruption coverage and getting venereal disease in the backseat of your vehicle?
No, not straight business interruption, but sort of, maybe I'm trying to draw a little bit of a correlation there, but that's not where I intended to go with it.
All right, let's say goodbye to our guest. We're taking up his valuable day trying to get through. You're just coming up with new, novel concepts and around this argument that's never going to win. Just failing, just falling down this mountain slowly, Stan. Thank you, Brett. I appreciate your time. And if anyone wants to get a hold of Brett or his partners, remember it's look for NGRV or Nigh, Goldenberg, Raso, and Vaughn. Brett, we really appreciate you coming on today. And
awesome. Thank you so much for having me on.
Yep. Thanks, Brett.
Thank you, everyone. Have a great day.
This episode of David vs. Goliath is over, but your journey is just getting started. To share your story with us, visit dolmanlaw.com. That's DOLMAN law.com or call 866-965-6242. The insights and views presented in David vs. Goliath are for general information purposes only and should not be taken as legal advice for any individual case or situation. The information presented is not a substitute for consulting with an attorney, nor does tuning into this podcast constitute an attorney-client relationship of any kind. Any case result information provided on any portion of this podcast should not be understood as a promise of any particular result in a future case. Dolman Law Group. Big firm results, small firm personal attention.